All right, welcome back, outdoor industry law students, and this is going to be the fourth video in the session 3, and thankfully for you, the last video and this is going to be dealing with agency law, and that's really liability of the organization for actions of their agents. We normally think of agents as employees or independent contractors. So we're going to do a quick review of agency law. So I'm going to share my screen again. And share liability. Okay, here we are. Liability of principal for agents' actions. The purpose, obviously, of an agency is for an organization to be able to do business through agents, and that can be different types of agents, employees, independent contractors. But that's how business conducts business, is through people. So this is a very broad area of the law, and a lot of law around it, in employment law and all the regulations that go along with that. We're going to just focus quickly on contractual liability of the organization for contracts entered into by the agent, as well as tort liability for torts like negligence committed by an agent of the organization, and if the organization would be liable or not. So let's go first to looking at, let me go to put this on slideshow from the current slide. Authority. Basically the organization is going to give the agent a certain authority that can be written, which is and or oral, but normally written. It's your job description, is actual express authority. That is what the principal or the organization is authorizing you as the employee or the agent to accomplish on their behalf, and it's expressed. The other is implied, and this is kind of looked at by virtue of, for instance, if you're hired as a salesperson, then it's implied, and it's implied in your relationship with customers that you might talk about the specifications of particular products, or you might have implied authority to discuss, how the products might perform under certain circumstances. That's also, and so it's implied from your position. Related to that, and very similar, is what we call apparent authority. And this is kind of looked at from the customer side again, and they say, is this customary for the agent to be involved with? So that if they do make a representation about, say, the sufficiency of a particular product to fit that customer's needs, then I as the consumer can rely on that, and it's within what we call in the law the apparent or implied authority. So it is those types of warranties, contracts, and that sort of thing would be within the authority granted by the principal or the organization. And the fundamental rule is very simple. The principal is liable, the organization is liable for contracts entered into by the agent if the agent's acting within the agent's express written, the job description. Implied authority, the authority that would implicitly go along with the position. Or apparent authority, if the consumer, based on the position that the agent is hired for, if it appears to the reasonable consumer that they could rely on the contracts or statements made by the agent, then the principal is going to be bound. That's that simple. When we talk about contracts, obviously oftentimes we're talking about written contracts, and but this would also apply to representations and warranties that a party may make to a consumer. So the organization is bound by those contracts entered into pursuant to the authority, either express, implied, or apparent authority of the agent. What's the difference between an employment relationship and an independent contractor relationship? I know one of the students was very interested in this, and this happens a lot with, say, outfitters and guides. In fact, we have an example, and one of your assignments is to take a look at the taking sides example that's in your content, course content folder, and evaluate that scenario. And it's actually a scenario between a outfitter and a guide, and whether the guide is an independent contractor or an employee. So the employment relationship exists where the principal, the organization, really controls how a party conducts their business, and how it does it, how the party does their job. So we look at things like, does the employer set the hours? Does the employer provide tools? Does the organization provide detailed discussion on how to do, how to conduct the activities? Are they paid by the job or by the hour, or a salary? So if you're paying somebody by the hour or salary, then obviously that looks more like an employment relationship. So you look at those kind of factors to determine whether it's an employee relationship or an independent contractor relationship. Employees are agents of the organization, so the organization is liable for those actions that are that occur within the course and scope of the authority. So we call this respondeat superior. That's your Latin for today. Let the superior respond. An employer is liable for the unauthorized torts. I mean, unless you order somebody, organization authorize somebody to, for instance, make a misrepresentation, which you certainly, our businesses certainly wouldn't do. So it's an unauthorized tort. You didn't authorize the driver to negligently miss a stop sign and get in a wreck, but the organization is still liable for that negligence because the driver is driving the bus within the course and scope of employment. So they're to and from the pickup spot, they're and drop-off spot for perhaps rafting. They're within the course and scope of employment. You do get into disputes about course and scope of employment. If you can prove that the employee is on, I love this legal term, a frolic and detour, then, I mean, they're acting so far out of the scope of employment, then the employer would not be liable. For instance, if that employee took the bus and was outside of the route for the pickup or deliver or take in or pickup, and instead was running a personal errand and got in a wreck, then that would be something for which the organization may not be liable. Now, the organization may have auto insurance that would cover it, but that's another issue. So recognize that there are situations where there may be a negligence or tort committed outside the course and scope of the employment arrangement. Okay, going back now to independent contractors. That's a person who contracts with another to do a particular job and who is not generally subject to the other's control over the manner and the means of how they conduct their work. So in other words, they're hired because of their expertise. So we look at independent contractor indicia such as they have their own licensing, they have their own tools, they have their own certifications, they actually have their own business. That's one of the biggest tests, is do they do this business for other persons, and is their financial success dependent on only one entity or organization or multiple? And that gets close calls sometimes when you have an agent that works for one particular guy that works for one particular outfitter all the time. So recognize that there will be questions about whether a party is deemed an independent contractor, even if you may not have control over how they do their business. But do you exercise such control over setting the schedules, setting times, providing them with some of the equipment, and that sort of thing. This is a big area of law that about misclassification of workers between independent contractors and employees, because one is obviously this vicarious liability situation where generally um, the organization principal is not liable for the negligence of a true independent contractor. And so when somebody's injured, they try to claim that no, they're actually an employee, and there's often close calls. The other area where it really gets litigated is in the employees. You've probably seen it with Uber and some of the gig economy. Some have claimed that they're actually employees, so that they would be entitled to overtime, entitled to unemployment insurance, entitled to workers' compensation, entitled to benefits. I think I mentioned cost reimbursements, that sort of thing. So we've got kind of the gig workforce, which doesn't fit very well in either employment as an employee or an independent contractor. So obviously Uber and others have contended that they are the drivers are independent contractors. So in any event, recognize that, and that we will run into issues around using parties that we believe are independent contractors. They commit an act of negligence, and then the party sues not only the independent contractor but also the organization. Take a look at the taking sides portion of your assignment and your analysis, and you'll see how difficult it can be to come up with one answer or another. All right, we talked about being liable as a result of the actions of the agent. Now we're talking about liability of action of the principal. It's called direct liability. So if the principal orders their agents to commit a tort, and that actually happened in a State Farm case where apparently the State Farm asked, or according to the complaint anyway, requested that adjusters classify losses related to a particular hurricane as flood damage rather than wind damage, even if it was wind damage, because flood damage is partially subsidized under flood insurance, which is partially subsidized by the government. So they actually had authorized the commission, allegedly had authorized the commission of that of a tort. So that's an example. It doesn't happen very often because companies normally want to do business honestly, right? The direct liability for a tort, not liability simply because the agent, ran the stop sign within the course and scope of employment, or the employee did, but where the employer is liable for their own actions in failing to look at background checks when we hire a employee or an independent contractor for that matter, or so negligent hiring, negligent engaging, or negligent supervising, so that you don't supervise the employees or certainly the employees in such a way that gives rise to the claim for injury. For instance, if you're in a situation where you don't give sufficient instruction or training, that can be negligent supervision directed at the organization because of that exact thing. You didn't give enough. The organization didn't give enough supervision or training. That's different than simply being vicariously liable for the employee's actions because the employee was negligent. So just recognize that's why we have drug testing. That's why we have looking at criminal background checks, driving records, all that sort of thing is negligent. And that's why we go through, in part, mainly to keep consumers safe, and customers safe, but also to make sure that we are doing what would be considered reasonable in supervising employees, giving appropriate training and so on, so as to not be found liable for negligent supervision. So, all right. This is kind of just a summary. Let me go back. That's a summary of tort liability of the principal. You'll see we talk about indemnification, that if there is a unauthorized tort committed within the course and scope of employment, obviously the third party can always sue the agent or the employee and the organization. And sometimes, I'm right up here on this one, sometimes the organization, the agent may have to indemnify the principal for that tort. You may have an agreement that, in other words, pay for the damages associated with that tort. You might have an arrangement and policy with the organization that if it's simple negligence that the agent commits, that the principal would actually indemnify the agent for claims associated with that. So just take a look at that summary page. And this kind of goes without saying, but tends to be overlooked. The agent or the employee is liable to the third party for your torts. So even though you're acting on behalf of a employer, or as an independent contractor, you're acting on behalf of a party that has engaged you for a project, vis-a-vis the third party, you are liable for the torts you commit. Now, whether you have to reimburse the organization for any losses that it may suffer really probably has to do with the kind of tort that you committed. If you committed a fraud, for instance, an unauthorized fraud, that would be a situation where the principal, if they were found responsible through vicarious liability, could come back to the agent and say, wait a minute, you misrepresented what these products would do. That caused us X amount of dollars, and we're going to seek indemnification from you, the agent, for our losses. Like I said, oftentimes companies will have arrangements with their employees that if the act is a simple act of negligence and the agent or employee gets sued in the course and scope of employment, and the agent or employee is liable for a certain amount of damages, then the organization may indemnify pay the employee for the expenses and any damages that might be rendered against them in the action. You really need to check with your organization to see if that type of indemnification for your duties as an employee are covered. So with that is the end of the discussion on agencies and the end of this video.